Hello and welcome to yet another episode of the new series. My name is Pooja Dwivedi. Today we are going to discuss the recent dispute between the CM of Punjab and the Governor of Punjab with respect to the powers related to the summoning of State Legislative Assembly. This topic is going to be extremely important from the perspective of GS Mains Paper 2nd and also from the perspective of your preliminary examination. So without any further ado, let us move on and talk about the following points. First of all, we are of course going to pay attention to what is the news, what is the dispute that we are going to, because of which we are discussing today's topic. Can the governor refuse to summon the assembly? What are the articles of the constitution? On what grounds has the Punjab governor refused to call the assembly? Can the government summon the house without governor's approval? Issues related to the post of governor, as in why there is always some sort of dispute with respect to the position of governor and the CM and the way forward. So, first of all, let us look at the news. Solicitor General Tushar Mehta has told the Supreme Court that Punjab Governor Banwarilal Purohit, he has summoned the State Assembly for a budget session. Now, this came minutes before the Supreme Court was about to go on for a hearing at this particular point only. Earlier, the Governor of Punjab refused to summon the State Legislative Assembly, and that caused tension. The tension is with respect to, the dispute is with respect to a disagreement, we can say, because the CM was unable to give certain information about the appointment done under him and the governor did not like it. Moving ahead, so first of all, let us talk about the dispute. Governor has earlier refused to give his approval for Punjab Cabinet's decision to summon a budget session of Vidhan Sabha from March 3rd. The governor had earlier raised several questions on appointments by the government. There was certain lack of information which could not, the information which should have reached the governor on behalf of the CM did not reach the governor, and that created tensions. Whereas the CM said that 3 crore people elected him to be the CM. And that is why he is not really answerable to the governor. Also, under that only, the governor threatened to seek legal advice on the issue. Now, this became the problem. First of all, let's talk about, can the governor refuse to summon the assembly? As we know that governor is not elected but appointed by the centre under the president's hand and seal. So, what happens is that whenever there is a dispute between the elected and the unelected, we have to walk a tightrope. Let us see. Now, what happens that the governor has to take any sort of decision only with the aid and advice of the Council of Ministers, not only, but with the aid and advice of the Council of Ministers. In a very few matters, he or she has discretionary powers. That means discretionary powers mean that he and or she can take decisions by their own choice. Constitutionally, the office of the governor has little discretion to not act on on the cabinet's advice. Now, according to Article 174, a governor shall summon the house at a time and place, or as she thinks or he thinks fit. Okay. Now, this is of course not depending upon the whims of the governor, but the aid and advice of the Council of Ministers. Now, under Article 174, Clause 2, Subclause A, governor may from time to time prorogue the house. Then, according to Article 174, Clause 2, Subclause B, it allows the governor to dissolve the Legislative Assembly. Moving on. Now, according to Article 163, Clause 1, there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the governor in the exercise of his functions, except insofar as he is by under this constitution required to exercise his function or any of them in his discretion. See, generally what will happen, what is this provision saying? The CM will be there to advise the governor, and there are certain circumstances where the governor can act on his or her own discretion. And now the joint reading of the two provisions, they leave the governor with minimal discretion in summoning the house. And this is the reason why under this dispute we can say that this seems political in nature. Now, in 2016, a constitution bench of the Supreme Court in Nabam, Arabia And Bamang Felix versus the Deputy Speaker, Supreme Court expressly said, that means Supreme Court made it very clear that the power to summon the House is not solely vested on in the governor. So this is something that Supreme Court had earlier made it very clear. So remember this particular case. Now, according to Article 167 of the Constitution, the duties of the Chief Minister is there to furnish information to the governor. Under this article, citing this article only, the governor refused to summon the Legislative Assembly. It shall be the duty of the Chief Minister of each of the state to communicate to the governor of the state all decisions of the Council of Ministers, so that there can be proper coordination that relates to the administration of the affairs of the state and proposal of legislation, to furnish such information relating to the administration of the affairs of the state and proposal for legislation as the governor may call. Okay. And if the governor so requires, to submit for consideration of the Council of Ministers any matter on which a decision has been taken by the minister but which has not been considered by the council. So we can say this is a give and take relationship of information between the CM and the governor. And when there is a lack of exchange, these sort of disputes happen. But there are certain exceptions where the governor can take the decision on their own discretion. Suppose when the Chief Minister has lost the support of the House. Now, because the strength is debatable, now the Chief Minister, going by this only, he or she lacks the credibility to give any sort of aid and advice to the governor. Here, governor can exercise their discretion. According to Article 174, the Council of Ministers approves the government's decision of convening of the House. Okay, it's the Council of Ministers. The government then writes to the governor about the cabinet's decision that please, we want to summon the House. Now, according to Article 175, the right of the governor to address and send the messages to the House are there. Now, 175 says that once 174 has been practiced, 175 brings the governor into picture. And the governor has the right to address and send messages to the House. Now, the governor may address the Legislative Assembly and may for that purpose require the attendance of the members. Okay. Moving ahead, the governor may send messages to the House, whether with respect to a bill then pending in the legislature or otherwise as well. And a House to which any message is so sent shall with all convenient dispatch consider any matter. That means very simply that governor works on the aid and advice of the Council of Ministers according to the Constitution. Now, according to Article 176, the governor has to address the House at the commencement of the first session after each general election of the LA and at the commencement of the first session of each year. The government has to make a provision regulating the procedure of the House. Now, it's not with the governor, these are preliminary facts. The conduct in the House is dependent on the government's rules. Okay, moving on. Now, what are the issues that are related to the problem that arises because of the dispute between the governor and the Chief Minister? See, what happens that generally the governors which are appointed, they certainly, in most cases, they belong to a certain political party, because if they want to get political exposure, they of course have to belong to some political party. So because of that, they sometimes are not very, neutral. They always will try to favor a party because of which the governor is in that position. From center's representative to center's agent, this is one of the biggest criticism of the post of governor. In 2001, the National Commission to Review the Working of the Constitution, it held that the governor owes his appointment and his continuation to the union. So naturally, because of this particular nexus, they will try to favor the union. And when the state government is not the same as the union government, the same party is not ruling in both the state and the center, what happens? There is a big problem, and the governor starts to act as a agent of the center. Now, there is also many times it happens that although there is a very little chance of the governor using their discretionary powers, even in this little scope, even with this little scope, they tend to use it. Removal of governor is also not written on what grounds they will be removed. So that is why, because of this only, it becomes really impossible to remove the governor. There is no clear distinction between constitutional and statutory role as the head of the state and also as the chancellor of the university. Because of this also, what happens? A lot of disputes occur. There are many constitutional loopholes which make the governor actually a center's agent rather than a representative. But we have to, first of all, as a way forward, try to build a committee which includes all the important stakeholders and even the chief minister of the state, of which the governor has to be appointed. There is also a need that neutral people are selected as governors. Then there is also a code of conduct, need of code of conduct, so that lesser disputes happen and the citizens of the state can benefit the most from this particular code of conduct. So that's it. Thank you so much for watching and stay updated.